All right, good afternoon, everyone. We're here in State versus Ashley Benefield. I've got Miss Benefield here in person, along with her attorney, Mr. Taylor. Present for the state is Miss O'Donnell, and it looks like Mr. Foster is also sitting there with her. And I know we had several different things scheduled for today. I also noticed that there's a court reporter in front of me. Who hired the court reporter?
I did, Your Honor. I'm John Saman. I represent the witness on the motion to compel a discovery deposition.
All right. Well, can I assume that you do civil work?
I do.
So it's typical where one of the parties will hire the court reporter to be present. Just so you know, in criminal, pursuant to the rules, we have digital court reporting.
Yes, sir.
And if there needs to be a transcript, the digital court reporting office will provide the audio from this hearing to the 12th Circuit official court reporters, and that will be the official transcript. So you're free to keep your court reporter here. That is not an official transcript.
Fair enough, Your Honor. I read one of the prior proceedings, and it looked like there were some errors in it, and so just to be on the safe side, I wanted to just have something to refer to. But I do civil work, but I was a prosecutor for 5 years, so I'm a stranger in a strange land, but I still remember the language.
Understood. I just wanted you to know,
Yes,
whoever
sir.
hired her, this is not an official transcript.
Fair. It'll just be for my benefit then. Again, if there's any errors or issues that I have with the official transcript, I can present it to the court and the parties, and you can digest that as appropriate.
All right. The first thing that I have is motion to compel discovery deposition. And that's the state's. So let me get everything in order. All right, let me just ask a couple of questions to make sure I understand where we are at. State, did you list Dr. Barbara Russell as a witness in this case, either category A, B, or C?
I did.
Which one?
A.
Category A. Have you, was this deposition, or Mr. Taylor, did you take Dr. Russell's deposition pursuant to the state's listing of her?
No, sir.
All right. Did you, defense, list Dr. Russell as one of your witnesses on your discovery response?
I do not believe so. However, give me just a moment. No.
All right. But you were going to take her deposition pursuant to what? Your disclosure or theirs?
Mine.
All right.
Yes.
So she's listed as a Category A witness by the state, so you can take her deposition. All right. Now I'm up to speed.
Okay. And you want me to go?
Yes, ma'am.
Okay. So I think the issue here is sort of multifaceted. I think with the argument about privilege that it's sort of twofold. So I'm going to break it down. So I know that my initial motion did not have some of these things in it, but we got the response last night, and so I have added some issues. So in this issue of privilege, I believe that there's going to be two parts. There is a waiver
You got a response to what?
to my motion from Dr. Russell's attorney. It was filed last night.
Okay.
You didn't get
I
it?
did not, no.
Okay. Let me get it. You can print it?
Is that this binder?
Yes, sir.
Oh.
Oh, I just literally got it handed to me. I haven't even looked at it.
Oh, okay, so I think, just to summarize, I think most of this response has to do with privilege and has to do with the evidence code and the privilege, psychotherapist, patient privilege, and that type of an issue. And I'm sure that they can make their own argument. But that's why some of mine now encompasses that.
I have one motion to compel discovery deposition, and it says certificate of good faith is June 6, 2024. Is that the only one there is, or is there another one?
That's the only one.
Okay, I've got it.
Okay. So, and then today, Judge, I sent you a copy of a waiver that was signed by Ms. Benefield. I can hand it up to the court. I have an extra copy if you need it.
That I was provided.
Okay. So my initial argument is going to be about when this waiver was signed and anything previous to that. This waiver was executed by Ms. Benefield that was releasing information, including Dr. Russell's information, to Detective Warren of the Manatee County Sheriff's Office, and it was executed October 12th of 2020. So the evaluation that Dr. Russell did previous and anything up to when this waiver was signed, I believe is under a different category. The court, but it basically, the three cases stand for the premise that once an execution of a waiver has happened, that they cannot go back and unexecute the waiver for the information that was already given. So regardless of who uses that information at this point, the waiver was executed at that time. So my argument for everything before the date of this execution, or the date including the 12th of October 2020, would be that this waiver of confidentiality applies to that information. After the execution of this waiver, it is the state's argument that the relationship between this witness and the defendant was no longer a professional relationship that was governed by the psychotherapist-patient privilege. And I'll just go through some dates. The shooting happened on September 27th of 2020. The defendant was out of custody for a time before her arrest. And you may need to ask the witness, Judge, but it's my understanding that this defendant lived with Ms. Russell before her arrest, when she was arrested on this charge. Then once she was in custody on this charge, there was a bond reduction hearing on November 20th of 2020. And at the time, Dr. Russell spoke on behalf of the defendant at the bond reduction hearing. And I'll read just a section, and this is kind of why I mentioned this in my motion. There are some semantics, I believe, about my use of the word professional relationship, and I think that Dr. Russell calls it a client, but I would see those two things as the same. But I'm reading page 17 of the bond reduction, starting at line 12.
Do you have a copy?
It's in the binder, sir?
It is in the binder. It's
Tab 5.
Okay.
And I'm just going to start at line 12. This is Dr. Russell saying, and she was homeless after the shooting, and the idea of her sleeping in her car or going from a cheap motel to cheap motel with trauma experience, I was very concerned about. My question to her, and that is professional with your line of professional ethics to put a client in your home. Her answer was, she was no longer my client. I had conducted the evaluation. I had submitted the report. I maintained contact with her because I knew I would likely have to testify in an upcoming injunction hearing. So there's more to that, Judge, within the transcripts, but that's basically my argument at that point is this witness was clearly showing that her relationship was no longer what I would consider legally governed under the privilege, that this is more of a personal relationship. She has now moved this person into her home. I suspect that you're not going to get a lot of professionals in the area of psychotherapy that would condone moving a client into your home and calling that a professional relationship. So it is the state's argument that once this move happened, this relationship, that is evidence that clearly this relationship was more than just a professional relationship governed by the privilege. And so at that point, the privilege is, it doesn't attach. So there, quite frankly, doesn't need to be a waiver. The last thing, Judge, is just that Section 90.503 is the section about psychotherapist patient privilege. And subsection 4C of that indicates when the privilege does not attach. And I'm sorry, but I was trying to find it.
It's in tab 4.
Oh, you have it in tab 4 as well? I knew you had a copy. Well. Okay, under section 4, there is no privilege under this section, and then it would be subsection C. For communications relevant to an issue of the mental or emotional condition of the patient in any proceeding in which the patient relies upon the condition as an element of his or her claim or defense. And then it goes on, it does not apply. In this particular case, the defendant has made this allegation of domestic violence and domestic abuse and has hired experts in that field. So the state would argue that that section of the statute applies because this defendant has actually made it an issue in this trial. So for those reasons, I would ask you to grant the motion to compel the discovery deposition.
All right, was that your opening?
Sorry, I thought that was my argument that you were asking for.
Okay.
Yes.
Did you want to make an opening?
No, sir.
All right. Did you want to make an opening as the attorney for the witness?
Yes, sir.
All right. And if you would please again just introduce yourself for the record.
Certainly. May it please the court, counsel. My name is John Samaan, S-A-M-A-A-N, and I represent Dr. Barbara Russell. Your Honor, I think the best way to address this specifically is to track what the prosecutor stated. So she described Category 1 using her timeline, and I've been provided with a copy of the document that she referred to. This document is not consistent with the requirements of CFR when it comes to HIPAA. HIPAA releases have to have a duration. HIPAA releases have to have specific information that's not consistent and not contained herein. If, in fact, the court considers that a waiver, then I would submit that the plain language of this waiver is very clear. It says, for the express purpose of, and by using the word express, there can be nothing implied. So the express purpose is providing information regarding my mental health, their observations and impressions of my relationships with Douglas, Benefield, and their observations and impressions of my relationship with my daughter, Emerson. This was executed, according to this document that I have in front of me, on October 12, 2020. Presumably, and I am not involved in the defense of this case and haven't seen the discovery and don't need to, but presumably that conversation occurred with a conversation with Detective Warren of the Manatee County Sheriff's Office, where it says specifically in this waiver that Ms. Benefield was providing authorization for these parties to communicate with Detective Warren of the Manatee County Sheriff's Office. Not a deposition, not anything else. And I would contrast the case law that the prosecutor provided because it's different, especially the Hamilton case. What you'll hear as we get further into this is whether or not there was a complete waiver, where in Hamilton there was. But in this case, there is a specific limited waiver. And Hamilton doesn't say that any waiver is a full waiver. They said if you waive, you waive. But with the limitations contained in this document expressly limiting the waiver, I think that all parties have to honor that. The information that I saw based on the deposition transcript, which the court also has a copy of in the same binder, at the end of tab 5, the only individual who stated that my client had a personal relationship was the individual asking my client the question. At no point is there any fact from any witness on either side that said that my client, Dr. Russell, had a personal relationship. And the facts are contained in the testimony that the court has in front of him. I don't think it's appropriate for us to put words or intent into my client's mouth based on what she clearly said. I think the opportunity to do that was at these hearings. Well, could you clarify that? What do you mean by she was no longer your client, but you still maintained a professional relationship? And she's here today, and if we're going to have an evidentiary hearing, I think that's a fair question, one that I plan on asking her myself, and I'm sure that the prosecutor would as well. But based on the plain language of what they have in their motion, what they're seeking to depose my client on, and what my client has objected to, is based on a supposition that my client at some point stopped having a professional relationship and started having a personal relationship, which again I submit to the court, based on the record that we have in front of us, there's no fact to support that. With regard to the exception, before I get to the exception, so that is the post-waiver content, because clearly that happened after October 12th. With regard to the exception...
So let me make sure I understand. There's no argument that any statements that were made by Dr. Russell to Detective Warren of the Sheriff's Office, those are in?
Well, candidly, Your Honor, that wasn't part of their motion, and so I was going specifically what was contained in their motion, and they only referenced things having to do with this purported personal relationship. So I received this document. I've had a chance to
But
review.
your argument is that you want me to read this literally. That's fine.
Well,
I will. And so if I read it literally, anything other than the express purposes, I'm not to read anything implicit, just the express purposes, those are waived. Well, you said if it's actually a waiver.
Correct. I don't know that this is a sufficient waiver. And when this document was disclosed, there's on the top of this page, Your Honor, I would submit that it says Discovery 12/7/2020, page 375 of 1000. In the disclosure, there is a disclaimer by the state of Florida that says there are documents in here and there's information in here that is governed by HIPAA, and you are advised to make sure before you disclose it that you comply with HIPAA. So my position, Your Honor, is that if this is a waiver and the information gained by this waiver is bound by HIPAA, then this waiver is required to have the requirements of a HIPAA waiver, which I submit it does not. And to the extent it goes any further, I think that I'm stepping into Mr.
Fair
Taylor's end of the swimming pool, and I think that's appropriate for him to argue. So I can't concede that point, Your Honor, that everything here is fair game. Number one, because that wasn't specifically what I came here today for, and number two, I think there's much more to uncover. With regard to the exception, I don't know that I have standing to argue that, because the prosecutor's argument, well, number one, it's not, I don't see that in their motion either, but to the extent that argument goes towards defense in this case, I'm not privy to that, and it has nothing to do with Dr. Russell.
Understood.
Fair enough, Your Honor. Thank you.
Thank you very much. All right. Go ahead, State.
Judge, I will call Dr. Russell to the stand, please.
All right. Dr. Barbara Russell.
Do you solemnly swear or affirm the testimony you're about to give in this case to be the truth, the whole truth, and nothing but the truth?
Hello, ma'am.
Good
afternoon.
Make yourself comfortable. Get about 8 to 12 inches from that microphone. Just speak in a loud, clear voice, and we'll hear everything.
Very good.
Go ahead.
Please state your name for the record.
Barbara J. Russell, Russell.
And when did Ashley Benefield live at your house?
From October of 2020, probably about mid-October, until, I don't even remember exactly when. It was approximately 9 months, maybe just under.
And who lives at that house with you?
Myself, my husband, and my daughter.
And how old was your daughter at the time?
19, 20,
And how many bedrooms does the house have?
5.
And so I would assume Ms. Benefield had her own room.
Yes.
Did you see her on a daily basis?
Most days, briefly.
Did she use your bathroom?
She had her own,
It was in your house.
of course.
Did she use your kitchen?
Yes.
And just to be clear, your house is not a shelter or anything like that. It's a personal residence.
Correct.
No further questions, Judge.
Mr. Taylor, questions?
No questions at this time.
All right. And it was Mr. Seaman.
Saman.
Saman. All right. I'm going to put there you go. Yes, sir.
Thank you. Dr. Russell, I want to ask you very brief questions because I don't want to open any doors, so I want you to listen carefully to the questions that I'm asking. Do you recall testifying at a bond hearing?
Yes.
Okay. Do you recall, well, actually, let me just get right to this. Do you believe that your interactions that have been asked about are protected by the privilege contained in 9503?
Yes.
Are you considered a psychotherapist because you are a licensed clinical social worker?
Yes.
Are all the times that and you've spoken with the prosecutor before,
Yes.
and one of the times that you were interacting with her was at your deposition, which was, I believe it was held in May of this year?
Yes, May 14th.
Okay. And you testified earlier that Ms. Benefield lived in your home for a time period.
Yes.
And you understand that you're here today because the state is trying to compel you to testify about your interactions with her.
Correct.
And do you believe that your interactions with her are covered by the psychotherapist-patient privilege?
They absolutely are.
Have you had a chance to review Florida Statute 90.503?
I did.
Okay. Is it your testimony today that the privilege that you are asserting on behalf of Ms. Benefield is being done so pursuant to the statute?
Yes.
Have you received any evidence that Ms. Benefield has waived that privilege?
No, I have not.
Are you asserting your privilege because the information the state is seeking includes information about any diagnosis made, any advice given by yourself in the course of your professional relationship with Ms. Benefield?
Yes.
I have no further questions, Your Honor.
Redirect.
Actually, Your Honor, now, if I may, I have a question.
Okay.
The reason why I passed the first time, Your Honor, is because Dr. Russell is his witness. And the basic argument is between the state and Mr. Saman. But I do have a question of Dr. Russell.
I disagree, but okay, go ahead.
Thank you. Russell, through your practice, you're familiar with HIPAA
Yes,
and HIPAA's requirements?
yes,
You're no stranger to it.
no,
You require a HIPAA release before disclosing any material that's confidential and comes under the umbrella of the privilege.
yes.
Is there a staleness element to HIPAA?
There is a staleness element to HIPAA, and there's a staleness element to any type of waiver that is signed by any client of mine.
Dr. Russell, other than the waiver that Mr. Simon brought to your attention, which was dated in 2020 of October, I believe, have you been presented at any time since then with a fresh HIPAA waiver?
No,
That's all you want.
All right, now redirect.
Are you asserting this privilege because Ashley Benefield asked you to?
no. I'm asserting this privilege because it's a requirement of my license to assert the privilege, as I explained in the deposition.
Okay. How long have you been in this field,
30 years,
in this area?
since 2009 here in Florida.
So I would assume that you know a lot of colleagues that are in the same business.
Yes.
Correct? Have you known any personally that have moved a criminal defendant into their house?
I don't know.
Relevance?
Well, I think it's beyond the scope of cross, so sustained.
And you said you would require a HIPAA release, correct?
Yes,
That or a court order, correct?
yes.
Thank you. No further questions.
Okay, thank you very much, ma'am.
Thank you.
Any other witnesses?
No.
Mr. Taylor, any witnesses?
No, Your Honor.
Mr. Saman?
No, sir.
No other witnesses. All right. All right, State.
Judge, the only thing I have to add is that according to the rules of evidence for the waiver of the privilege, it has to be waived by the defendant, not the therapist. So I would argue that that is not a proper defense to this request to take a deposition. And I would also stand by my previous arguments.
Mr. Taylor?
I can go first. Judge, I'll go first on this one.
Okay.
The statute is very clear as to who may raise the objection. It specifically says, and I'll just read verbatim from the statute.
Are we saying raise an objection or assert a privilege?
I'm sorry, assert the privilege.
All right, yes, sir.
And it says here, under subsection 2, the privilege may be, it's 3, may be claimed by the psychotherapist, and this is section D, the psychotherapist, but only on behalf of the patient. The authority of the psychotherapist to claim the privilege is presumed in the absence of evidence to the contrary. So there's no evidence to the contrary, and so my client is fully within her right and, frankly, required to do this. The other thing that I would point out, Your Honor, just generally speaking, is the evidence that you heard today has not changed from the evidence that was submitted to the court in the form of the deposition or the bond hearing. My client has maintained that she has a professional relationship with the defendant. She's never wavered on that. I think it would be inappropriate to have the state try to get the court to infer something else when those facts are simply not in evidence. The last thing that I would say is that in some of the case law that I provided, the courts have found that if there is going to be an involuntary waiver that's found, and clearly this is not a voluntary waiver, that it is not something that is common, and it's not something that can be invaded without an actual showing. The last thing, and I would talk about the reason for my motion for a protective order, is that the state hasn't established a necessity of why this testimony is required to a point that would overcome what is clearly privileged and what has clearly been asserted in a timely fashion. I won't add anything more than that, Your Honor. I know that Mr. Taylor wants to.
only addition I would have, Judge White, is pursuant to that same statute which governs psychotherapist patient privilege, section 9503 of the Florida Evidence Code. Under section 3, as Mr. Saman noted to Your Honor, the statute states the privilege may be claimed by, and under A, it includes the patient or the patient's attorney on behalf of the patient. We claim it. Thank you.
All right. All right, there's,
I didn't hear the last, what you just said.
Said we invoke it.
rebuttal.
No.
All right, I'm left with quite a few questions that weren't answered. First and foremost is I have no idea how Dr. Russell became involved with the defendant. Was she personally retained? Was she retained by an attorney as part of a dissolution case? Was it part of the CPT as Dr. Broder was? So she was retained by DCF or the Department of Health or the Sheriff's Office. What was the purpose of her retainment? Was it, again, for a dissolution case? Was she to render some kind of opinion? Was it mental health? Was it occupational? So I have a whole bunch of questions that weren't answered about what was the purpose here and who hired her. More importantly right now, though, is this. Mr. Taylor, I believe in the disclosure or the notice of intent to rely on battered spouse syndrome, am I correct that Dr. Russell's name is listed?
Off the top of my head, Your Honor, I do not believe so.
All right.
But I additionally would respectfully correct, Your Honor. I asterisk that notice. It is not battered spouse syndrome, but it proceeds similarly.
Okay. So the real crux of my question is, do you intend to call Dr. Russell as a witness in your case?
Respectfully, I do not.
Because I just want to be clear, I'm going to make a ruling based upon the arguments and the evidence I have in front of me. But if we get in the middle of trial and the defense stands up and says, we call our next witness Dr. Barbara Russell, and she has invoked the privilege to avoid the opportunity for the state to question her at a deposition, that is gamesmanship that will not fly for me.
Well, I understand, and I don't wish to engage in gratuitous banter with the court. There's been plenty of legitimate reasons. That would not be my intention, but I would also tell the court, please be mindful of Ms. Benefield's Sixth Amendment right to call witnesses her own behalf. That said, I can't predict how the trial will unfold, but I tell the court as an officer of the court, as I stand before Your Honor now, we have no plans to call Dr. Barbara Russell.
Okay. Let me just look through and see if I have any additional notes or questions. All right, there's one. We had a couple more. I'm not sure which ones were actually noticed, though. Were there any others that were noticed?
I think Your Honor expressed a preference for resolving whatever was outstanding. Perhaps Suzanne will correct me if I'm wrong.
I don't know if an actual notice was filed, but I know we cleared time for the 911 motion in limine.
All right, so let's take care of that one. The last one is, and we don't have to hear it today, but I do have a colloquy that I want to have with Ms. Benefield on the request for the paralegal to remain at counsel table for trial. So there'll be a colloquy I want to have on that. All right, I will issue an order.
Okay, thank you, Your Honor. May I and my client be excused?
Yes, sir.
Thank you. Thank you, Dale.
All right, so, now hold on, let me just look real quick. I know I've got a couple hearings at 4. And I know that I didn't start you guys until 3:30. I completely acknowledge that. But I just don't want to, if we're going to take another half hour and I can get these other ones done pretty quickly, I'd kind of like to do that. Do you have time or do you want to?
Well, I have time.
All right, Ms. Benefield, can you step back into the audience? And I want to, Madam Court Reporter, are you packing up?
Yes.
Perfect. You can go ahead and do that now.